big thanks to this wonderful audience. I was a little concerned when I saw it was 77 degrees outside. Thank you all for being here. It means a lot. Big thanks to you, Attorney General Nick Brown, for the time. You seem a little busy sometimes. Our Seattle University President, Eduardo Peñalver, leads us off.
Welcome. Great to have you here at Seattle University. I thought I'd start with maybe a little bit of just an orientational question for the audience. Before you were elected as Attorney General for the state, you served for several years as the U.S. Attorney in the Western District of Washington. Can you explain the difference between these two legal jobs? How does your day-to-day change as you move from the federal prosecutor's office to the Attorney General?
Well, first, I appreciate the welcome, and thank you all, everyone, for coming. Looking forward to this conversation. The U.S. Attorney's job is different in substance and in scope. As the U.S. Attorney, you are the chief federal law enforcement officer for Western Washington. Every state has at least one U.S. Attorney. Washington has two, divided by Eastern and Western Washington. And you're principally responsible for advocating on behalf of the federal government on both criminal law and civil law. The vast majority is in the criminal space. About 80% of the work is prosecuting cases on behalf of the federal government, working with federal and state law enforcement officers. And then you also represent the United States in all of the civil litigation that happens in the district, both on affirmative cases like civil rights enforcement on behalf of the Department of Justice, back when the Department of Justice did civil rights litigation, and environmental enforcement, and then also representing the United States on defensive cases. So here in the Western District, that meant a lot of medical malpractice defense on behalf of the military installations, or if a post office driver gets in a car accident with a citizen and you sue the federal government, you are represented by the United States Attorney's Office. The scale and scope of the job as the Attorney General is vastly different. One, obviously represent the entire state. Two, it is principally civil work on behalf of the state. We represent every state government agency in Washington. Not every state is situated like that, and in many states, agencies can have their own independent in-house counsel. In Washington, as a matter of law, state institutions have to be represented by the Attorney General's office. As a consequence, I have a tremendous amount of lawyers and staff that work for me. For context, in the AG's office, I have 834 lawyers. We're the second biggest law firm on the West Coast, second only to the California Attorney General's office. When I was the U.S. Attorney, I supervised just under 80 lawyers. So it's 10 times bigger. And we do all of the representation of state government, but also I have a separate independent authority to represent all of you. And so I very much take seriously my job as the advocate for the people of the state of Washington. The Constitution empowers me and me alone to advance cases on behalf of the people when it comes to some of the affirmative civil litigation, healthcare, civil rights, whatever. And we bring a number of cases, many of which are in the news. We're actually up to 15 now because we filed 2 more cases yesterday. But also at any given moment, we have thousands of cases, both defensive and affirmative cases. So, and now I have 13 offices all across the state, and spend a lot of my time working with our colleagues across the state. So my schedule is busier than it was when I was U.S. Attorney. The other big difference for me personally is that I don't have a boss for the first time in my professional life. I report only to the voters of the state of Washington, and we also represent our clients, much like any lawyer represents clients. In the Department of Justice, I had a lot of independence, but I worked for the Deputy U.S. Attorney or Attorney General and the Attorney General of the United States, and served at the pleasure of the President. So I could be removed by any time by the President of the United States.
It seems that Democratic attorneys general now have 2 jobs. One, the basics, some of which you mentioned, consumer protection, civil rights, antitrust, and 2, protecting Washingtonians from certain actions of the new federal government. If this is true for you, seems it might be, how are you managing what amounts to 2 jobs in one?
Well, it's certainly taking on more than it used to be, but this is not entirely a new endeavor. For many years, attorney generals of both parties have been bringing litigation against the federal government. A.G. Ferguson in his prior role quite famously brought, I think, 100 cases against the Trump administration. And that was new in terms of the scale, but attorney generals of both parties have been litigating against the United States for a long time now. Many years ago, after Obamacare passed, there were a number of state Republican AGs, including the Washington Attorney General, who sued the Obama administration over the legality of Obamacare. During the Biden administration, Republican attorney generals brought cases against Biden policies, et cetera. It has increased in scale and significance, principally from my view, because our current president doesn't care about the Constitution. And second is acting with more aggressive use of the executive authority than ever in American history. And so we, as attorney generals, I think have an obligation to respond to that, to defend the rule of law, to defend our state constitutions, and to defend the United States Constitution. So it has certainly increased, but it's not entirely new.
So we're still in the early days of your first term. It's been about 100 days. It feels like 100 years sometimes. But when you were running, you didn't know who was going to be president of the United States. So I assume you came in with certain agenda, certain priorities for your time as Attorney General. As you kind of enter this, second quarter of your first term, what are those top priorities for you? How have they changed in light of the occupant of the White House, and how have they stayed the same?
Well, and what I want people to know and to remember is, even though a lot of the public's attention, and rightly so, gets drawn to the national litigation, as I said, I think at any given moment we have thousands of open cases in the AG's office, and the 15 that we file against the president, and maybe just a small handful of those, are what draws the public attention. But at any given moment, there are lawyers and professional staff working very, very hard on behalf of their clients and behalf of Washingtonians that never get the time and attention that, frankly, that they deserve. So I want to make sure that people recognize that there's so much happening in the office that has nothing to do with the president, and those cases are often the most challenging. We're talking about protecting children in child welfare cases. We're talking about defending the state in very difficult tort litigation. It's not as sexy or as interesting as suing the president of the United States. But for me, I really wanted to focus the agency more on some things that I think get to the things that most of us are caring about on a day-to-day basis. Traditionally, we have not done, as an agency, as much casework or policy work around issues around public safety, and I really am trying to drive more focus around how we keep the public safe, both by working with local prosecutors, but also getting to the things that I think really make safety sustainable, and that has nothing to do with police or prisons or jails. There's a lot that we do that impacts the things that we all worry about on a day-to-day basis. And again, that's usually little to do with Donald Trump or the president, whoever the president is. How much am I paying in taxes? Is my community safe? Do I have health care? What is the quality of my kids' education in my neighborhood? Those are the things that really matter, and frankly, the AG's office touches a lot of that. But there are core sets of obligations, in my view, of protecting Washington values. There are things that make us unique as a state, and I see that on a daily basis. I see that when I talk even to my Democratic Attorney General colleagues across the country. There are things that we are going to do differently. And those are highlighted mostly in our affirmative litigation, and highlighted in particular when we see a real attack on rights and values and freedoms coming from the White House. And so consequently, a lot more of my own attention gets drawn to that. When you sue the president, and it's done under my name, it's something I have to pay a lot of attention to. And I wish we weren't in this moment. But the moment that I think we're in is defending Americans from their president. And I don't say that easily. I've served in public sector the vast majority of my career. I started my legal career in uniform, serving my country, including a year spent in Iraq during the height of the Iraqi war. But it is necessary, in my view, in this moment, to defend Americans from their president. And that's a pretty scary reality. Shifting
back to where you started that answer on the local level, one of the concerns that comes up over and over again in public polling in the Seattle area is public safety, and the Attorney General isn't a frontline prosecutor in our state. So can you say a little more about what the AG's office can do and does do to support public safety?
Yeah, well, first, it's interesting because a lot of people think we are prosecutors, and I don't know how often I hear from the public, either in conversations or when I make the mistake of looking at my Twitter account, which my staff tells me not to do, but I can't stay away. Like, why don't you prosecute this and that, and why don't you investigate this? And the reality is I do not have any original jurisdiction over the vast majority of criminal activity. All of that is delegated to local county prosecutors. There's a very small subset of cases where we do have original jurisdiction over a certain class of sexually violent predators. But for the most part, the Attorney General's office can only bring cases at the request of the county prosecutor or at the governor's request, which has happened from time to time, particularly around uses of police misconduct or where there's been a controversial or complicated police use of force. The governor has often requested the Attorney General's office to investigate. That happened, for example, with the Manny Ellis murder in Tacoma, Pierce County. But for the most part, we don't do those cases without being asked. But I made very clear coming into the door to talk to the Prosecutors Association and the Sheriffs and Police Chiefs Association to tell them that we wanted to do more, that it was important for me to be as much of a resource as we could be for local law enforcement, to take on cases where there's a conflict of interest and to be more resource, and we've already upped the intake there. And I've spent most of my law career in and around criminal justice issues, but I started as a criminal defense lawyer when I was in the Army, defending soldiers of crimes. And I think far too often when the public thinks about crime and public safety, they only think about prosecutors and jails, which are very much, in my mind, part of the solution, but a very temporary part of the solution. 97% of the people that we put in state prisons are going to get out, and rightly so. And we, as a justice system, and need to be thinking about all the things that lets those people succeed when they get out and prevents them to get there in the first place. And there's a lot of work in the AG's office around mental health support and drug counseling. And what keeps people out of jail is a good education and a good job opportunity and community support. And those are all things, both through our casework and through our policy work and through my own advocacy, that we should play a larger role in. You want to reduce crime, give people affordable places to live. Addressing the housing crisis, for example, reduces crime. We don't think about those intertwined as much as we should, but there's a lot of that work that I would love for us to see us play a larger role in.
Washington State is now part of 15 lawsuits, as you mentioned. All I did was read the Seattle Times piece that said 13, waited till 3 o'clock in the afternoon and it changed. But
you're not following us on Twitter,
That's it. How do Democratic AGs, and we've been told that you meet virtually a couple times a week, how do you decide which state leads on which case? How did you, for example, become lead on birthright citizenship, which is before the Supreme Court next week?
Well, there's a lot of factors that go into it, and it is one of the aspects of my job that I did not anticipate would be such a big part of the job, is that for better or worse, I'm talking to my Democratic colleagues 3 times a week at least. Our staffs talk on almost a daily basis. There's tremendous upside in that collaboration, and there are some downsides, both in time and resources and all that. But over a year ago, the Democratic states started preparing for the possibility of a second Trump administration, to look through Project 2025, to look through the statements by the president on the campaign trail, to prepare for what we are now seeing. And as much as the president lied about not knowing what Project 2025 was, it is very clear that that was their playbook. And so there was a lot of research and collaboration amongst the states to think about issues that we might be facing. And so as a result of that, a lot of states took a leadership position on certain substantive areas. And as a result, when cases now come about, a lot of the decision making is based on, in part, who's done some of the work, in part, who has the resources and scale of an office to lead on a particular case, and in part on just strategically where is that the right court to file a case in. Not every court jurisdiction is the same. The precedent in the Ninth Circuit is different than the Fourth and the First, et cetera. Consequently, we've somewhat strangely filed a bunch of cases in the District of Rhode Island in the last 100 days. The upside around collaboration is that there is no way that Washington or any other state could lead all of these cases independently. We just don't have the capacity to do that. So we share resources a lot. The downside is when we join a multi-state case, when we're not in a leadership position, we lose authority over that case. And so, for example, a lot of the cases that we filed in Rhode Island around the illegal funding cuts, we're not a lead state on. And so, as a lawyer and you want to file a motion to compel or do discovery, you have a lot of control over that until you let some other state lead about that. But there's probably 5 or 6 states that really have the capacity to actually lead one of these states and one of these cases. Washington being one of them, along with New York and California, Massachusetts, Illinois, New Jersey. But there are a lot of states that have much, much smaller offices and don't really have the opportunity to lead, or certainly not lead, multiple cases. So, some of the smaller states really want to be engaged, but they have, 80 lawyers or 100 lawyers, and they're doing a broad scope of work just like we are. And so Washington consequently has decided to lead on a number of these issues. And there are some things that I just really care about.
Is that the birthright citizenship?
Yeah, we led on birthright citizenship in part because we had been the lead state on opposing the Trump travel ban in 2017. Our team had done a tremendous amount of work around preparing for some of the immigration-related executive actions that we're now seeing. In part, that is why we also led the illegal cuts to transgender healthcare, because Washington had taken an outside role in that. And because many of my client agencies, University of Washington and others, had been national leaders on that particular area. And not every state's going to be impacted in the same way as well. So if you look at some of the cases challenging the illegal mass firings of federal employees, that obviously hit the District of Washington, D.C. and Maryland more than any other state. And so it was important for those states to take a leadership role in those cases. And so some of it is just who's impacted differently.
Over the past few years, I think we've seen a number of cases in which legal theories have migrated from kind of the fringe of the legal community to the center. Yeah, I'll go there eventually. I mean, one example was, the presidential immunity case where I think, as it was being litigated, a lot of legal academics, including a lot of conservative legal academics, didn't think it really had a chance to prevail at the Supreme Court, and then at least, in part it did. I have this fear that something similar might happen with birthright citizenship. You kind of reading the tea leaves, do you share that worry? What are your thoughts on the viability of the legal arguments you're seeing, against birthright citizenship?
Well, I think it's right to categorize it as a fringe legal theory. It's a little hard to predict, of course, how the Supreme Court will rule on such a case. It is not clear to us, even if the arguments that are happening next week are going to get to the merits of the issue, rather than some issues around the scope of relief and national injunctions and the like. But it is very clear that fringe legal theories have taken hold. And I call fringe, I'm obviously a Democrat. But I also, more than anything else right now, my job is to enforce the law and the rule of law. And I very much separate my decision-making around, there's a substantive issue, and I think reasonable people can disagree about a host of things the president has done. You can disagree about how much funding federal agencies should get and how big federal government is. You can disagree about whether citizenship should be defined by where you're born or who your parents are. I think reasonable people can disagree about all those things. That is not why I filed suit in those cases. We filed suit because what the president has done is illegal. and unconstitutional, and that has driven the decision making for me. But, less well supported or fringe legal theories get support, and then some people who believe in those theories get appointed to the bench or take prominent positions in academia and elsewhere, and fringe legal theories then become a little bit less fringe. There is a reason that the vast majority of challenges to Biden executive actions were filed in a very small district court in Texas. It's because that particular judge supports a lot of what I would consider fringe legal theories. It's also in the Fifth Circuit, which is the most conservative fringe supporting appellate court in America. And we have seen our current Supreme Court certainly has a more openness to supporting what I would say are fringe legal theories. It is very, very hard for me to imagine that the Supreme Court of the United States would overturn birthright citizenship as we know it. I think Justice Alito will probably go there because he's the worst Supreme Court justice. But even Justice Thomas, who I disagree with on almost everything as a matter of law, he is a true, legitimate scholar of Reconstruction history, and I struggle to see how he would overturn birthright citizenship. But nobody makes money on predicting what the Supreme Court will do, so I won't.
No handicapping.
Bet on it.
Yeah.
Nick Brown, Washington and Oregon are suing the federal government for trying to change election rules, which we're pretty sure would limit voting access, especially in our state. Is this a simple power duel over who controls elections, or does Washington's provision allowing mail-in ballots to be postmarked rather than received by Election Day make us a little vulnerable on this?
Well, this is one of those issues that I was just talking about. We should have robust debate about voting in America and the right way to do it and the qualifications. I think that is a healthy debate in America. What the president is trying to do is take over the state's sovereign right to manage their own election systems, and he simply has no authority to do that. And I've personally struggled in the last 100 days about raising the alarm for this moment that we're in as a country without seeming like an alarmist. Because I think if you look at my resume, and for people that know me, I'm very much a believer in the power of government to be a force of good for people. I'm very much a public servant. I'm certainly not an activist or a reformer in many ways. What is happening right now in America should scare the hell out of all of us. And I really mean that. And the executive action around voting in America is a good example of that, of the president trying to take authority over voting where there is clear law that says he has no such authority. And I don't know exactly why he's trying to do that. My defense of that in that lawsuit is not because, not really on the substance, but really to affirm the rule of law and the right of states to set their own standards. And every state's a little bit different.
But Washington, by allowing the ballots just to be postmarked, I wrote so many editorials over this, it's enough to bore whoever had to read them. But to that point, we might be vulnerable on that point.
Vulnerable to what?
Well, because it's, the ballots aren't in. They're not counted on that day.
But do you mean vulnerable to
challenges
fraud, or?
like this? No,
Oh,
to
yeah.
challenges like this, exactly.
Well, we're going to win this lawsuit. We, California, have very similar systems. I'm not even suggesting it's necessarily the right way to do it or the wrong way. I very much believe vote by mail is the best way to do voting, but whether you count it on election day or simply it has to be postmarked, I think people can disagree about whether that. But I don't feel like our case is vulnerable for that.
So stepping back from specific issues, at the federal level, the Attorney General is appointed by the President. Here in Washington, you're elected separately from the Chief Executive of the state, the Governor. How do you, as an Attorney General, think about, or potential tensions or divergences that might arise in your policies or priorities with a governor of the same party, or this presumably it could be a governor of a different party at some point? How do you think about that tension between those two offices, and how would you navigate those?
Carefully. Well, I mean, we have a separately elected attorney general, I think, for a reason. Not every state does that. There are some states where the AG is appointed by the governor. That's true in New Jersey and Hawaii, for example, and Maine. In Maine, the attorney general is appointed by the legislature. In Tennessee, it's a little bit of a weird combination of factors. Most states are like Washington, it's a separately elected, but not every state does it that way. And both the governor and I wear multiple hats. For me, the governor is my client. The office of the governor and the governor himself are clients of the Attorney General's office, just like the Department of Transportation or Department of Commerce is. And so we provide them legal advice and represent them if they're sued. And that's a really important role for us to have. But I have the independent authority to represent the state of Washington. I'm the only person that can bring cases on behalf of the state of Washington. And there have been times in our history where the governor and the attorney general disagreed. Most famously in Washington was over Obamacare, where Attorney General McKenna made the decision to join the Republican coalition of states challenging Obamacare, and then Governor Gregoire very much did not want him to do that, and they fought about it. I've known Governor Ferguson for over 12 years now. We've had a good professional relationship. It's weird where the governor's also had your job before and knows everything about the office. And there might be times.
Didn't he try to cut your budget?
He tried unsuccessfully. Yes, he did. Well, no, I mean it was a little strange, to walk in the door and Governor Ferguson was proposing to cut my budget by over $40 million, which we successfully opposed the vast majority of that. But we're also facing a real budget crisis in Washington, so I don't begrudge him the effort. But there might be, I'm sure there will be matters where we disagree, and we will have to navigate those together. Our staffs talk, the governor's staff and the AG staff talk very frequently, multiple times a week, and so it's a careful relationship, but it's an attorney-client relationship in many ways, and then it's two separately electeds with their own scope of authority and responsibility, and I'm sure there'll be times we disagree, and we'll just have to navigate those.
You alluded to this earlier, but it's the degree and the number of lawsuits, I guess. But is the current level of legal activity by Democratic state AGs, did you borrow that in a way from Republican attorneys general during the exact thing you just mentioned, during Obamacare? Texas AG at the time, Greg Abbott said, I go into the office, I sue the federal government, and then I go home.
I wish I could go home after just doing that.
So you covered the first two? No, just...
Well, as I said, you should look at my calendar. It's like every day it's 10 different subject matter areas. And sometimes it's a little dizzying for me to bounce from getting briefed on this tort case to getting briefed on this consumer protection case to also planning some management decision or hiring decision. And then also, hey, by the way, we're planning on filing these two new cases against the President of the United States. But what we're doing now, certainly, in 2025, it's a vastly higher amount of cases against the federal government that happened 20 years ago. When A.G. Ferguson first led Washington's suit against the Trump administration in 2017 against the Muslim ban, at the time I was the governor's counsel, so I was on the ground working with the AG's office on that case. But Washington was sued the president alone. No other state wanted to join. Now that changed, and more multi-state cases happened. But at the time, most Democratic states in the country did not want to be part of that. And there was a lot of reluctance around suing the president of the United States. And that has changed, obviously. And I sometimes I laugh when I see complaints from conservatives, Republicans saying, well, President Trump or Biden only had these many injunctions against him and Trump has this many. It's like, well, here's a lot of illegal conduct and here's a lot less. And that is why I think really we have so much more activity now. It's not a matter of a pure change in philosophy or approach. It is a matter of having a president who's lawless.
So I thought I heard you hint at my next question when you mentioned a lot of cases being filed in Rhode Island. TV legal analyst Jeff Toobin recently wrote that liberals love lawyers and often take their cases to sympathetic lower federal courts. So I ask you, how much truth is there to that? And is it still perhaps the best way to get these cases before the highest court?
Well, like every lawyer is going to be strategic. You don't, like the Democratic AGs would never file a case in the Northern District of Texas because we would almost certainly lose on these challenges to the president's authority. Conversely, Republicans, as I said, have brought a lot of cases to that district. And we have to be strategic about not only the district court, but the appellate court. And the Ninth Circuit, for example, has changed pretty dramatically in the last 10 years or so. There was a time where the Ninth Circuit was viewed as, and rightly so, as the most liberal, progressive court in America. That is very much not the case anymore. So, in a prior era, it might have made more strategic sense if you're advancing democratic legal principles, although I don't view them as Democrat or Republican, to bring more cases out here. But that's not certainly the case anymore. We have a very strong, in my mind, district court in the Western District of Washington. And I would love to continue to bring cases out here. But when you're dealing with multi-state jurisdictions as well, sometimes you have to be very strategic about where you bring those cases. And as a result of the 15 cases that we filed, I think 3 or 4 are in the Western District of Washington. The Massachusetts, DC, and Rhode Island have gotten the rest of them.
So you mentioned the Northern District of Texas, and I think in an earlier answer you mentioned this issue of national injunctions. And I just thought it'd be helpful for the non-lawyers in the audience if you could explain what is a national injunction, why would it be the case that a district court in Northern Texas, a trial court, would have the power to issue an injunction for the entire country? Is that overreach? Is it a good thing? What do you think on that issue?
Well, in very simple terms, courts have the authority to issue an injunction when a challenge is brought. An injunction essentially says, federal government, well, in this case, federal government, you no longer have the authority to advance with this executive order or whatever action you're taking. The court could limit that to just the state where that action is brought, or they could bring it nationally. And we certainly saw in the last 10 years pretty sweeping national injunctions stopping executive action, both by the Biden administration and by the Trump administration. National injunctions were much more common. There has been a real noticeable shift away from that, where appellate courts are being much less likely to grant national injunctions. And to me, that's not a conservative or liberal legal philosophy. I think there's a lot of, there's some really good arguments to say, well, you shouldn't have national injunctions when only parties are being impacted in a particularly discrete area. A good example for me is when the president illegally cut grant funding to the National Institute of Health. Every Democratic state joined that lawsuit. The injunction that was granted in that case meant that only relief came to those 23 states that participated, which means all of the conservative, Republican-led states in America did not benefit from that injunction. Alabama, for example, gets by far is in the top 2 or 3 number of states that get NIH funding. But when the injunction was granted in that case, they did not benefit because they didn't participate in that litigation. So there are some issues where it makes sense. There are others where it's a little harder. For example, at least in my mind, it would be hard to say birthright citizenship is legal in Washington, but illegal in Texas. In theory, you could do that, but then it would be a real question if you're granted citizenship when you're born in Washington, and then what happens when you travel to Texas? Do you lose your citizenship? Have you lost your country? So a lot of issues where it's hard to imagine a court granting relief that wasn't nationwide. If Congress passed a law banning assault rifles, which they should do, but if they did that, it would be hard for a court to say it's legal in some states, illegal in others. But there has been a real tightening around the use of nationwide injunctions, and that is really the main issue that the Supreme Court is going, or has indicated they're going to decide around birthright citizenship next week. In theory, they could decide the whole substantive merits of the case, but at least right now, they've indicated that the case is going to be around whether it was appropriate for Washington and the judge in Massachusetts to issue nationwide injunctions stopping the president's executive order, or whether it should have been limited to those states participating in the case.
So, court can either order the government to stop doing something or order the government to affirmatively do something. I think in recent weeks we've seen cases where in response to those kinds of orders, the government either continues doing something or fails to do the thing they were ordered to do. As an Attorney General, how do you think about what your powers are? What are the powers of courts themselves to enforce their orders when the government does that?
Well, there's the way that things have traditionally gone and should go, and the way things are going now. Well, let me first say, I think for the most part, our system is working in the way it should work. The president's doing things that parties, states are arguing that it's illegal. We file cases. Lawyers for the states and the Department of Justice go to court. A judge has a hearing, issues ruling, et cetera. And for the most part, in all of the cases that we've been a part of, and some that we have not been a part of, for the most part, the federal government is abiding by the court's decision. There's been a couple cases that we've been involved in where it hasn't happened as quickly or as thoroughly as we think it should have. In some of the grant funding cases that we brought, we continue to see states have certain funds be cut off that we thought were covered by the court's order. And so then we did what is normal. We go back to court and say, either a motion to compel or a motion to enforce your judgment. And for the most part, the department and the government has complied. And really just in the last couple of weeks, we're dealing with what I view as pretty overt disregard for court orders, particularly around some of these immigration cases that we are not a party in. And I really don't know what's going to happen. We continue to see judges have hearings, force the Department of Justice to come defend their positions. We've seen a real, from my view, stonewalling by the Department of Justice. And in the last handful of years, the Supreme Court has expanded the power of the president. Rightly or wrongly, that is true that presidents today can legally get away with a lot more than they could have 20 years ago. I think one of the reasons that it's been important for us to bring cases not only against the president, but the administration and departments more broadly is because it is one thing for the president to ignore court orders. It is another thing for Joe Smith, head of whatever agency, to ignore court orders and to be subject to both civil and criminal contempt provisions. And also, every lawyer for the Department of Justice has a duty of candor and ethics. And when they go to court and argue positions on behalf of their client, they should not do it in disregard for their ethical obligation. And I think we've seen a number of lawyers toe that line. And as much as I am very clearly frustrated with our current president of the United States, as someone who grew up professionally in the Department of Justice, I think what we're seeing in the deterioration from the Department of Justice, it personally troubles me more than a lot of the other conduct. The Attorney General of the United States, who is certainly the most powerful law enforcement officer in America, if not the world, her current view is the 2020 election was stolen. I mean, it is beyond absurd. About a month ago, she said quite explicitly, and this is almost an exact quote, that the Department of Justice would find and root out and get rid of Department of Justice employees who oppose the President of the United States. This is the top law enforcement officer in America saying that you are going to be rooted out because of your political beliefs. I mean, that is scary to me. And that permeates the Department of Justice, the FBI, and who knows where else. And that is coming from the top of the highest levels of government. And because of that is their general legal philosophy and position, and again, this should trouble everyone, whether you voted for the president or you did not, whether you support his policy objectives or you did not. Can you imagine if Merrick Garland had said, we're going to find and root out everybody in the Department of Justice and FBI who voted against President Biden? Can you imagine the uproar in America? And I think we need to speak the truth in this moment more than anything else right now. And that is certainly how I feel. And so, I worry about DOJ lawyers going to court, operating under this environment where they still have this duty of candor and ethics to their state, to their clients, but they're being put in or have chosen to be in very precarious positions. The lawyers to the DOJ that are arguing the case of the people that were deported to El Salvador illegally, they're being asked to defend their clients' actions and haven't had a whole lot to say. And I do worry about what this might mean in the coming days and weeks as we continue to litigate these cases.
So I just want to follow up on one thing. You mentioned the expansion of executive power, which I agree has been happening for decades, right? And it under both parties, right? The executive power continues to grow, and you see an increase in the use of executive orders, kind of steadily. I mean, this president takes it to new levels, but it's been happening for years, and people tend to like executive action when their party's in the executive power, and then they don't. Last year, the Supreme Court, overruled its decision, longstanding decision in the Chevron case, that extended judicial deference to executive agency actions. This is the Loper-Bright case, and when that happened, it was characterized by progressive lawyers as judicial overreach because it expands judicial judicial review of agency actions and kind of creates a lot of space for federal courts to second guess agency decision making. Now, right, we want judicial oversight of executive action, and so is there a contradiction there, or is that an example of just kind of we like executive power when it's our executive, or is there a principled reason to be both concerned about the overturning of Chevron and wanting more judicial oversight of executive action now that we have a Republican in the White House?
I guess I don't tie those two together in quite the way that you have. I think the Chevron decision might have been the most consequential Supreme Court decision that
Justice Stevens.
Very few people know about, right? Because it was overturning a precedent, and the end result is going to be a real empowering of judges to rule on things they know nothing about. In terms of pure logistics, it's going to cause our courts to grind to a halt and will necessitate, I think, a fairly significant expansion of the number of judges and courts in this country. If you have a federal civil case that is not one of the ones that we've been talking about, the likelihood that you're going to get your case heard in a timely fashion was dramatically decreased by that decision. I don't know necessarily if I think about it in judicial overreach kind of terms, other than it has empowered judges to have much more authority. But I think, I think there's fair criticism. When President Biden attempted to wipe out student loan debt, substantively, I was like, yeah, that's great. Legally, I think it was really questionable whether he had that authority. And you didn't see Democratic attorney generals suing to stop that. And so I think there's fair criticism. and people should hold me to that same standard. If we're talking about enforcing the rule of law, that should apply to everyone. And so I think, but I think more about how Democrats have responded to executive action of prior presidents. I'm sure if you ask Republican attorney generals today about the scope of what the president is doing, they would some of them would privately tell you, yeah, there's no legal authority for the president to do that. But none of them have joined a single one of our cases. But we are both the chief lawyers for our states and all partisan, which is the nature of our system. Washingtonians chose to elect separately their attorney general, and as a consequence, there's an electoral process and politics and all that goes into it. But I try to be very consistent in making sure that when I act on behalf of you all, that I'm doing that consistently with the law and my ethics and what I think is in the best interest of the public that I serve. Even though I know at best I'm going to make 55% of Washingtonians happy and 45% unhappy.
You're going next, right?
What is the overall importance of Harvard University's lawsuit against the administration?
Well, it's strange for me in this moment, even though I'm a Harvard grad, to be saying yay Harvard. Same thing for like Perkins Coie. It's not often that big law gets really their kudos, but yay Perkins Coie. I think it was a real important moment, not only for Harvard University, which obviously has the largest or one of the largest endowments in the world and probably has more flexibility to take on that bold stand. But I have been really shocked by the capitulation of major institutions or companies or law firms in America. And to see Harvard take a principled stand, I think really was not only the right one morally and ethically and legally, but it was also the right one pragmatically. I think the mistake that Columbia made is that you think that when you just agree and capitulate to the president's demands, that's it, that he's not going to come back for more. And I think that is the strategic error that Columbia and others have made. And I think Harvard recognized that if we say yes to this, there will be something else. But I, as a lawyer, I'm really distraught at what has been either silence or capitulation from the legal field. Perkins rightly made the same sort of analysis that Harvard did, and Washington State in our office led the amicus brief in support of them. 91 of the top 100 law firms in America said nothing at all. 91 of the most profitable, largest law firms in America refused to sign on to subsequent amicus briefs or to say anything in opposition, thinking if they just kept their head down that this would go away. And it is both, I think, a disregard for their legal obligation and their moral obligation, but really a strategic error to think that they would not be next and there would not be more asked of this president. So I'm really proud of Perkins, of Sussman Godfrey, and for the law students in this room, I hope you all think about where you seek employment in the future. And if you're someone who hires law firms, I think you should think very carefully about who you hire to be your representative. And if people will capitulate and fold on one person, they'll capitulate and fold on others.
President Trump believes he has a mandate to rule. Is there a good argument, doesn't sound like it, but I'm just going to ask it, to dial back the number of lawsuits they file? In other words, do lawsuits put Washington residents in more or less peril?
Well, the president, he won the election. The majority of Americans decided that he was the right person to lead this country. I obviously wish that we had made a different decision as a country, but I don't disregard his ability or authority. From my vantage point, I also won an election in Washington. The people in Washington had very stark choices for attorney general between me and a Trump supporter. They decided that I was the right representative for the state in this role. And I do not think that I should ever say, I'm going to allow the law to be broken because it might benefit us and my state. And not every case is the right one for us to join. I haven't joined every single lawsuit that had been filed by my colleagues. I make a pretty straightforward analysis about whether it's illegal, whether it harms Washingtonians, and whether we should or need to be a necessary party in a particular case. And in not every circumstance of what I think is an illegal action have we decided to join a case. And the fact that we have a president that acts with retribution and vengeance, I do not think should dissuade us. I would not be the right person for this job if I buckled under that sort of pressure. At the same time, we have right now the Attorney General and their border czar and the president talking about arresting and prosecuting governors and attorney generals. And I had a congressperson 2 or 3 weeks ago call for my prosecution, which is really strange. It wasn't a Washington congressman. But they were saying that I should be personally prosecuted because of our defense of Washington state law around immigration enforcement. And, in this moment, you can back down from that, or you can continue to stand on your principles and values. I do not disregard the fact that the president is and has been threatening to take action against states who are doing things that he disagrees with around immigration law, around DEI. But I do not think that we want leaders to cower because we have a president who behaves like that.
How do you, just thinking about that, some of the more outrageous things that the president calls for, some of them he does, some of them he doesn't do. And
like opening Alcatraz?
Yeah, exactly. How do you, how do you think about the sort of mental triage involved in responding, choosing what to respond to, what to ignore? Obviously, if you ignore some extreme suggestion the president makes, you risk, missing an opportunity to really underscore how outrageous it is. But at the same time, there's so much volume of outrageousness that it can kind of occupy your brain in a way that's also not productive. So how do you kind of personally think about that process of sort of mental triage?
And I'll just interject. I've been watching our time minder, and we have time for 2 more questions. So.
Okay. Well, I mean, like everyone, my job is to be Attorney General. It is not my life, right? I have 2 kids. Getting home for the myriad of sports activities that they have in this moment is the most important thing for me, to be present for them, to have my own private life, personal life, to connect with friends and family. Like, those are the things that I need to do to maintain my own sanity, much like we all do in our lives. It is something that I try to emphasize for my entire team, because as busy as I am, the people that are actually doing the litigation work on behalf of Washington, they're grinding it out right now. And so I'm very mindful of trying to maintain that work-life balance. The upside of the thing that I love most about my job is that every decision that I get to make matters. Every single one. Like, the things that come to my desk are the hard decisions on whether we're suing the president, or how we're resolving a difficult tort case, or managing an office of 1,900 people. I love the fact that everything feels significant. The thing that I don't like about my job is that everything feels significant. And about a month ago, I said to my staff, "Can you just bring me some easy decision today?" But I chose to be in this position, and I'm having so much damn fun being Attorney General. I really am. And it's an honor to be in this position. And I also recognize that it is limited. Like, I will be in this role for 4 years, maybe more, but at some point I won't be the Attorney General. And I need to maximize the moment. And, my friends and my kids, they keep me grounded, they keep me humble. You do give up some of your privacy and personal life. I get recognized a lot more these days. It happens when you're in the news and on the cover of the Seattle Times like yesterday. And it's a little strange to lose a little bit of your privacy. I got a little used to that because I was on Survivor 22 years ago. Well, that's another story.
Well, let's go there. I one of the things that the present moment reminds me of is reality TV. I feel like we're living in a reality TV show. But you were a contestant on Survivor, Australian Outback. And according to the website Survivor Wiki, you drew the ire of some of your competitors for being a relatively quiet character who they feared might fly under the radar and then pose a threat later. Was this a strategy that you brought to the show, or is this kind of stealthiness something that you just sort of a character trait that you employ in other settings as well?
Well, you have to keep in mind, when I went on Survivor, reality TV was like brand new. Nobody knew much about reality TV. When I told my Army Colonel father that I was dropping out of Harvard Law School to go on a Survivor reality show, he was really angry.
Seems fair enough.
You know, part of it was strategy. Part of it was, you know, if you choose to go on a show like that, you're kind of an A-type personality. And in my mind, I was like, look at all these A-type personalities. They're going to just kill each other and argue, and I'm just going to slide and be quiet. Part of it was my own mental health. Like, I can't exist in this turmoil. But I loved being on the show. It was a tremendous amount of fun, and I was on season 2, and now they're on season 48, and it's
Whoa. I didn't know
it's pretty remarkable. I was 23 and had earrings, and I was a young man, but it did, I sort of joke.
Everybody watched this, of course.
Well, it's still on Netflix or Peacock or something, but a little bit more seriousness, it was my first exposure to being somewhat of a public person, and I've reflected on that from time to time. That was the first time I got used to people recognizing me, which as a 23-year-old young man, it was pretty cool, right? I got to skip lines at clubs and do all these fun things. But then you also give up some of your privacy, and people think that they can come and put their arm around you and talk to you, and again, I chose to be on that, so it was voluntary, but it was a little weird experience of you lose a little bit of your identity, and people think what they see on TV is who you are, much like, when I take a position of a case now, everybody thinks that that's my personal substantive view, and sometimes it is, sometimes it's just because that's what the law requires. So, Survivor lessons.
Thank you so much. Thank you. We are now going to have some of your audience questions. I hope you've been thinking of them.
I'll take my mask off so you can see. One compliment and one question. The compliment is, I'm a former political press secretary myself, and I know that politics is all-consuming, so thank you for your service. The question is this. The Seattle Times reported in the early days of your administration that you and Governor Ferguson had a little dispute about collecting damages that the AG's office wins, and Governor Ferguson wanted it to go to the general fund, and you wanted to keep it to hire more lawyers and do more suits. Has that been resolved?
I actually don't think that's accurate. So I'm not sure we never had a dispute like that. So we had a dispute about him trying to cut my budget, and I opposed it publicly. But I'm not tracking with the specifics you're asking about, but my comms director is here, and we'll talk to you after this.
Yeah, thank you. I'd love to hear you expand a little bit more on the idea you were talking about protecting Americans from this current administration. And I'm wondering what kind of measures you are taking currently or are willing to take and plan to take to respond to their crackdown on immigration, and especially the authoritarian playbook we're seeing that targets students, whether we've seen it in Columbia or Tufts. So what are you and your office doing to ensure that if something like that was to happen in Washington, and we're already seeing different things with visa revocations, even at our own university, with Dixon being detained at Northwest Detention Center. Just what's your response, and how are you being proactive to deal with that?
Yeah, I think it's probably one of the more important areas that we are involved in right now. The scope of our authority is important, but also somewhat limited. So the most important thing that we need to do in this moment as a state AG's office is to enforce state law. The most important state law around immigration enforcement is the Keep Washington Working Act, which was passed in 2019, which set pretty clear limits about how state entities, including local law enforcement, could cooperate with immigration enforcement or not. It puts some pretty tight constraints on local law enforcement in that regard. I will tell you the single most difficult case that I decided to file was not actually against the president, but it was against the Adams County Sheriff for violating state law because of their explicit cooperation with ICE in contrary to what state law requires. Again, I think reasonable people can disagree about what state policy should be in that space, but it is pretty clear that state law prohibits what the Adams County Sheriff was doing, and so I decided to sue the sheriff and the county to set those clear limits. We also do a lot of work around immigration issues, around the labor and the workforce to make sure that people who are undocumented are not being taken advantage of or having their own rights violated by employers who threaten detention or enforcement in the workforce, and that happens a lot. At the same time, the federal government has pretty explicit and clear authority to do immigration work, and it is not the state's job to do immigration enforcement, nor to hinder it, really. So it is a difficult position for us to be in. But I do think the types of, and immigration enforcement has been happening for multiple presidents. I mean, President Biden, President Obama, President Clinton, all deported lots of undocumented people. What we are seeing now, however, is a real draconian, arguably fascist attempt to, I think, literally kidnap people off the street. And not only kidnap them, but then send them to foreign countries of which they're not part of. And the total disregard for their due process rights, again, should be alarming to people. And part of the reason I think it's really important for us to defend Keep Washington Working Act is that I don't want the King County Sheriff's Office or Pierce County or Adams County to be in that position of cooperating with the illegal erosion of due process rights. And frankly, most local law enforcement don't want that role either. The Washington Sheriffs and Police Chiefs Association has been pretty clear about establishing state law, federal law boundaries, and it is an important area for us to play a role in. But we can't. It is not our job nor our authority to oppose everything the federal government is doing, but to defend and protect the interests of people here in the state.
So as you may know, recently House Bill 1163, the bill to create a permit to purchase firearm system here in the United States, here in Washington State, was passed. It's something that you testified in support of. But given the administration's new approach to gun violence, such as getting rid of the Office of Gun Violence Prevention, are you expecting any legal challenges when this bill may be turned into law in Washington State? And how are you making sure that the gun laws that we have here in Washington State are still also protected and upheld?
I suspect we'll get sued the day that bill is signed. Washington has twice the number of gun deaths of New Jersey, 3 times that of Massachusetts. 950 people died by firearm violence last year. About 70% of those were from suicides. Gun violence, in particular suicides, is a real crisis in this state. And I use New Jersey and Massachusetts because those are obviously Democratic blue states that also have very tough gun laws. Something that we are doing is not enough. The permit to purchase bill is proven to show a real reduction in gun violence of all types, both criminal violence and suicide deaths. It is a really important bill. It's the only bill that I testified on this session. I believe thoroughly that that bill will save lives. I also believe thoroughly that the NRA and the Second Amendment Foundation here in Washington will sue. And our Supreme Court has been, our U.S. Supreme Court has been increasingly hostile to gun litigation. So I'm confident that that bill is good policy and good law under current precedent, but I am not as confident that the Supreme Court will ultimately see it that way.
Thank you. I think we have one question here. Yeah, I actually have about 1 million questions, but I'm going to stick with one. One of the bills that is floating around that's been approved by the House and is going to the Senate, which is of great concern, is the SAVE Act. And I'm sure you're very familiar with it, particularly in the fact that probably many women will not be able to register vote or re-register because their names are not consistent with their names on their birth certificate. So it's clearly a way of undermining the 19th Amendment. Do you see the SAVE Act in the same way that you see the president's overreach on his executive order relative to voting, and that it will take litigation if that's passed by the Senate, because he will certainly sign it.
I see them sort of similar in substance. In my mind, the genesis of both the president's executive order and the SAVE Act is because they want less people to vote. So I think the motivation is generally the same. The legal issues are going to be different. You know, if Congress passes a federal law and the president signs it, it is much more grounded in authority than a simple, executive actions aren't laws. They're not court decisions, they're not statutes. You know, the president has a lot of authority over executive branch agencies, but they're not laws, you know. And every time I hear people say, well, you know, the president made DEI illegal, it's like, no, he didn't. It's still very much legal in Washington, in the country. So you know, if that becomes law, whether a state would have standing to sue, whether we would be successful, like I feel very confident in our ability to oppose the Trump executive order around voting. Whether Congress passes a law, that's going to be a different matter. I'm sure it'll be challenged, maybe by states, maybe by including Washington. And we will obviously take a very, very close look at it if it does become law. And I'm not sure if it's going to get through the Senate, but we're watching.
So I want to thank you all for being here. I want to thank you, Nick Brown, for your time. Good afternoon.